My name is Nabilah Siddiquee. I am a supervising litigation attorney at the Immigrant Defense Project. We're based in New York, but I work remotely from here. So first I'll just say a little bit about IDP. We fight for fairness and justice for all immigrants who are affected by the intersection of the U.S. Criminal and immigration systems. And we fight to end the mass criminalization, detention, and deportation of immigrants through strategic litigation and technical assistance, legislative and policy advocacy, legal advice and training, and community defense. And we work to challenge the application of harsh and unfair immigration laws that target immigrants affected by the criminal system. So this past year, with the critical support of the McDowell Foundation, we have furthered our fight to end discrimination against non-citizens in state criminal sentencing reform and post-conviction relief. IDP has been challenging the Federal Immigration Agency's unfair position, which declines to give effect to retroactive state sentencing reform laws, which means that non-citizens don't get the full benefit of these state reforms when applying for immigration benefits or defending against deportation. So IDP has been working to challenge this agency position and help make good law. We have supported related efforts in the Ninth Circuit and the Second Circuit, and most recently in a case before the Second Circuit titled Figueroa-Vasquez v. Garland. We argue that the federal agency and the federal court must give effect for immigration law purposes to New York's new retroactive state sentencing law, which lowered the maximum possible sentence for all New York misdemeanor offenses. And this would primarily affect longtime residents who have U.S. citizen kids and spouses, and who would be mandatorily deportable for a single misdemeanor with no jail time imposed, and also non-citizen survivors of domestic abuse. So this past month, this is a photo of the litigation team after the argument at the Second Circuit. This past month, actually about a few weeks ago, the court issued a split decision that actually disagreed with us, and we are now seeking rehearing. We're still in the rehearing window. But we think it's very significant that the dissent in the case adopted our position. The dissent explains the interaction between state criminal law and federal immigration law in the way that the litigation team had been advocating for, stating that a retroactive state law must be treated as retroactive as a matter of law, including for non-citizens. And we see this dissent as an indication that there could be additional support on the court for our understanding. And nationally, this is the first dissenting opinion, we think, to adopt this position, and we see it as a first step towards better justice for immigrants. And we will know more in the next couple of months after the rehearing petition and amicus briefs have been filed. Thank you.